Good evening, one and all. And though we had initially thought that discharge and discharge sessions could be over in 8 sessions, but as Justice Ramkumar takes things in a simplified manner, we said that sessions could be more, but we should make the people understand better. And that's the way to take things forward. And in fact, section 221 itself, what we will be discussing today along with 221, it says where it is doubtful what offense is committed. So we thought that we shouldn't create some doubts in the mind of the audience who watch us live or subsequently, that what could be the gamut within the section 221 and 223. And as we are approaching the weekend and same time the fervor of Christmas is also approaching. So we thought, let's take the sessions accordingly. And I would request Justice V. Ramkumar, who has his own style of, I can say he is creating an audiobook for all of us. We can watch it any time, point of time. And that too, with creating of an impact, if one wants to watch it video also or on a this thing. Right. Without taking much time, we will request Justice V. Ramkumar to take things and explain the manner.
Good evening and thank you, Vikas. Now, last time we discussed sections 219 and 220, and we also discussed a few problems on those sections. Now, before we come to sections 221 and 223, you must have noticed that I have omitted 222 because section 222 is not an exception to section 218.1. We saw that under section 218.1, there are 4 exceptions. 218.1 says all offences shall be separately tried. All distinct offences shall be separately tried. We saw 4 exceptions: 219, 220, 221, and then 223. 222 is not an exception. That is why I have omitted section 222 in today's webinar. So today we are going to discuss the last of the 4 exceptions. Last of the 4 exceptions. Before that, let us have a quick recap into the topics already covered during the previous session. Friends, we noted that in the case of the offences of criminal breach of trust and dishonest misappropriation of property, joint trial of 2 or more cases, 2 or more offences is permitted only when the specific dates of the offence and the specific amounts covered by each offence are not available, in which case section 212 clause 2 Cr.P.C allows the lumping up of the total amount and the statement of the outer dates of the offences in the court charge, because the specific amounts covered by each offence is not available. The dates on which each offence was committed was also not available. So we follow the rule under section 212 clause 2, wherein you can lump up the entire amount and give the outer dates, the starting date and the last date. That is permitted. Where such details of each offence are on the contrary available, then separate trial is the rule. If all the details regarding each offence and each day and the amount involved in each offence is separately available, then go by the rule under section 218 clause 1, separate trial. Otherwise, joint trial as permitted under section 212, where 212 clause 2, where you can lump up the entire amount and give the outer dates, the initial first date and the last date. That is what we examined in last session. Then it was noted that for the commission of plurality of facts constituting the same offence, there can only be one punishment as provided under section 71 of the Indian Penal Code. There were plurality of facts constituting the same offence. There can only be one punishment. Similarly, we noted that sections 219, 220, 221 and 223 are the exceptions to the rule of separate trial under section 218.1 Cr.P.C. We also noted that in the case of plurality of offenders, so far we were discussing on offences. Now in the case of plurality of offenders, that is culprits, accused, and plurality of different offences committed during the course of the same transaction, joint trial can be resorted to by recourse to section 223 clause D, which we are going to discuss today, and section 220 clause 1, which we discussed the other day. So if it is plurality of offences, 220 clause 1. If it is plurality of offenders, it is 223 clause 1D. I am saying 223D of Cr.P.C. It was noted that while under section 219 clause 1 Cr.P.C, 3 offences of the same kind, not same offences, 3 offences of the same kind committed within 12 months can be charged and tried at one trial under section 220 clause 1. Different offences which need not necessarily be the same kind as defined under section 219 clause 2 can be tried at one trial provided they constitute part of the same transaction. See, often 3 offences of the same kind means they are different offences. But how do you find out whether they are offences of the same kind? The punishment should be the same. The punishment for those offences would be the same. Then you can call them offences of the same kind, but not same offences. Same offences means same offences. So they are different offences, but same punishment. Therefore, you can, that is the explanation given under section 219 clause 2. Then it was further seen that even if a case falls under any of the 4 exceptions to the rule of separate trial under section 218(1) Cr.P.C, joint trial is not a mandatory requirement and separate trial held in those cases will not be illegal. That is, the rule under section 218 clause 1 is separate trial for each distinct offense. But then there are 4 exceptions: 219, 220, 221 and 223. If the case falls under any of those exceptions, then it is an enabling provision allowing joint trial. But even in those cases, if instead of joint trial, separate trial, that is the main rule under 218(1), is resorted to, courts have taken the view that you can't call it illegal because you have resorted to the main rule, separate trial. That means the exceptions are not for the purpose of mandatorily conducting joint trial. They are the only enabling provisions where under the court will be justified in conducting joint trial. But if the court conducts separate trial, you can't call it illegal because you are resorting to the main rule. Then we also saw that even in a case which falls under section 218(1), where separate trial is the rule and distinct offences are there, they cannot be jointly tried. The accused can make a written application under the proviso to section 218(1), requesting the court that I may be tried jointly. Court can, if there is a written application, court can try the accused jointly. Then we noted that a solitary act directed against 2 or more persons will be treated as a single offense and not 2 offenses because 2 victims are, merely because 2 victims are involved. If the act is a solitary act, you are treated as a single offense and not 2 offenses of the same kind within the meaning of section 219 clause 1. Offense act is a single act, though victims are 2. We also saw that a repetition of the offences against the same person in the same occurrence will call for only one punishment as mandated by section 71 of the Indian Penal Code. For example, that illustration is beautifully elucidated. Illustration. That is 50 strokes. A person is beaten 50 times. Each of the offences is 323 or 324. And for each of the offences, if imprisonment is given, then he can be imprisoned for 50 years. The illustration beautifully says that he can be imprisoned only once because repetition of the offense in the same occurrence against the same person calls for only one punishment as provided under section 71 of the Indian Penal Code. We examined the scope of sections 220 clause 1, 220 clause 2, 220 clause 3 and 220 clause 4 and 220 clause 5. We saw the meaning of the same transaction in 220 clause 1. What do you mean by same transaction? We saw the accused can be jointly tried for different offences committed in the same transaction under 2 or more statutes. Can be IPC, Prevention of Corruption Act, or some other statute. If the facts constituting the offence need not necessarily be the same. 2 or more offences can be tried together if they are committed in the as part of the same transaction. Then we saw that if the facts constituting the offence amount to the offence under same or 2 or more statute, the accused can be charged, tried, and convicted at one trial, single trial for each of those offences, but only one punishment as mandated by Section 26 of the General Clauses Act 1897. These were the points which we discussed the other day. Now we pass on to Section 221, which is the third exception to the rule of separate trial under Section 218, Clause 1. Can anyone read Section 221, please?
So we will ask Mr. Rao, since he has joined after 3 weeks, that he will read it. Mr. Rao, you will have to KVJ Rao.
You have to be unmuted.
Yeah.
Can he unmute?
Yeah.
Can he himself unmute?
Yes,
Oh, yes.
Not, yes, you're unmuted, sir. Thanks.
You have that Section 220?
Yeah, I have.
221.
Yeah, Section 221. The first question. If a single act or series of acts.
Sorry, Mr. Rao.
Section 221.
We'll go through the section first. Then we'll
Section
try
2.
to understand the section.
Read Section 221 itself.
You will get it.
Okay. Question on Section 221. Yeah.
Yes.
What is the scope of Section
221? I will read it.
Not the question.
Section 221.
Section itself.
The section
doubtful
itself.
what offence has been committed. If a single act or series of acts is of such nature that it is doubtful which of the several offences, the facts which can be proved will constitute, the accused may be charged with having committed all or any of such offences, and any number of such charges may be tried at once, or he may be charged in the alternative with having committed some one of the said offences. If such a case, the accused is charged with one offence, and it appears in evidence that he committed a different offence for which he might have charged under the provisions of subsection 1, he may be convicted of the offence which he is shown to have committed, although he was not charged with it. Do I read the illustration also, sir?
Yeah, no. You can skip the illustration.
Yeah.
Now you can read question number 1.
Okay. Now Mr. Rao will read it. It's gone. What is the scope of Section 221 Cr.P.C. corresponding to the old Section 236 and 237?
See, Section 221(2), as we just now read, enables a court to convict an accused person for an offence with which he has not been charged, since it was doubtful as to whether the particular offence was committed or not. You may refer to a 4 judges ruling, AR 1960 Supreme Court 400, AR 1960 Supreme Court 400, rendered by Justice S.J. Imam, that is G.D. Sharma versus State of UP, AR 1960 Supreme Court 400. Then held that the court charged for the offence under Section 467 IPC, that is forgery of a valuable security, for making fictitious entry in the transport permits, could also fall under the lateral part of Section 477 capital A IPC. That is, 467 is forgery of a valuable security, and the lateral part of Section 477A, that is falsification of account. Supreme Court strained a bit to say that even the transport permits could fall under the expression accounts, and it was to hold that that offense, same offense may fall under the lateral part of Section 477A also. So the court is in a doubt at the time of framing the charge. The court is in a doubt as to whether 467 IPC should be the charge or 477A IPC should be the charge. Now the rule is under Section 221(1) Cr.P.C. if there is a doubt as to which of the several offences have been committed, the court may frame charge either for all the offences or for any of the offences in the alternative. Either all the offences or any of the offences. Under Section 221(2), If in a case falling under section 221(1), the accused was charged with one offence, but the evidence reveals that he committed a different offence, but for which he could have been charged under section 221(1), then even if he is not charged, even if there is no charge, he can be convicted for that offence revealed. For example, we examine 467 and the latter part of 477A. Same facts constituting an offence under 467 and 477A. Supposing at the time, the doubt should be at the time of framing charge. At the time of framing charge, the court is in a doubt whether 467 is the appropriate section or 477 capital A IPC is the appropriate section. Supposing the court frames only under 467 and during the evidence it is revealed that 477A is the appropriate section, then that is a section which could have been charged while framing charge. So it squarely falls under section 221 and 222 clause 2. The illustration to section, in fact, illustration A is a beautiful illustration. A is accused of an act which may amount to theft or receiving stolen property or criminal breach of trust or cheating. He may be charged with theft, receiving stolen property, criminal breach of trust, and cheating, or he may be charged with having committed theft or receiving stolen property or criminal breach of trust or cheating, either all or any of them. But if any of the other offences mentioned therein have been revealed in the evidence, nothing wrong in the court convicting him for that offence, because that is an offence for which court could have charged him under section 221(1) Cr.P.C. That is a guiding principle. We pass on to question number 2.
Sir, what is the primary condition for the application of section 221 Cr.P.C?
The primary condition is the court should have felt doubt at the time of framing charge. The time of framing charge, the court should have felt doubt as to which of the acts or series of acts alleged against the accused will constitute the offence. In such a case, section 221 clause 2 permits the court to convict the accused of the offence which he is shown to have committed, though he was not charged with it, but he could have been charged under 221(1). Beautifully stated by the Supreme Court by Justice K.T. Thomas in Shaman Sahib versus Multani, Shaman Sahib Multani versus State of Karnataka, 2001, Volume 2, SCC 577. 2001, Volume 2, SCC 577. Again, there is a Privy Council ruling also. Thakur Shah versus Emperor, AR 1943, Privy Council 192. 1943, AR 1943, Privy Council 192. Again, Bijoy Chand Patra versus State, AR 1952, Supreme Court 105. Judgment, the author of the judgment is Justice Saeed Fazal Ali. There are any number of rulings on that. The doubt must be as to the inference to be deduced from the above facts, thus making it doubtful which of the several offences the facts which can be proved will constitute. If that doubt is there, court can either frame a charge against all the offences or any one of the offences and can convict the offender for any of the other offences for which charge could have been framed. Again, AR 1988, Supreme Court 129 by Justice A.P. Sen. AR 1989, Supreme Court 129. This is the principle. Question number 3.
In a charge for offences punishable under section 498A and 304B IPC against the accused for subjecting his deceased wife to such cruelty and harassment as to drive her to commit suicide, is it permissible for the court to convict the accused without a specific charge for an offence punishable under section 306 IPC abetting the commission of suicide by drawing the presumption under section 113A of the Evidence Act along with or instead of section 498A IPC in a case where the offence under section 304B has not been proved?
So matrimonial cruelty along with the dowry death is attributed. Now dowry death is not, the prosecutor is not able to prove dowry death. Then the question is whether the court will be justified in convicting the accused for an offence under section 306, abetting the commission of suicide, falling under section 498A, in a way falling under 498A. The answer to this question was in the affirmative. Court said it is possible. In fact, there is no direct ruling on this point. It is possible, but then in fact, 498A. In fact, I will slightly make a digression on this 498A. 498A, there seems to be some confusion. See, in fact, a Mofussil advocate, a Mofussil lawyer, once called me and said that, sir, my client is the husband. He, in a weak moment, he slapped his wife on her face in a heated argument between them. That's all. He only slapped the wife on her face. Then she straightaway went to the police and lodged a complaint for 498A, cruelty, matrimonial cruelty. Now, have I got any room to escape? He asked me to read section 498A. In fact, it was the lady viewers on this platform may kindly pardon me, and don't misunderstand me. The idea came from the advocate himself. He asked me to read the section again and the explanation. See the explanation. If you read the explanation, 498A, what the legislature has explained. For the purpose of this section, cruel, because any husband or relative of the husband, if he commits cruelty against the wife, he is punishable with for a term which may extend to 3 years and also liable to fine. Now, what is cruelty? For the purpose of this section, cruelty means any willful conduct which is of such a nature as is likely to drive the woman to commit suicide. The willful conduct on the part of the husband should be of such a nature as to drive the woman to commit suicide or cause grave injury or danger to life, limb or health, whatever mental or physical, of the woman. Therefore, the husband's willful conduct should drive the woman to commit something, to cause harm to herself. So, taking the cue from the lawyer himself, I said that I only gave wings to his imagination by penning an article which was published in the Kerala High Court cases. And relying on that article, he got an acquittal, he told me. So, because I told him that you are right, merely slapping the wife, you are committing an offence under 323. It is not as if you are not committing any offence. You are committing an offence under section 323 IPC by merely slapping the wife on the face. But supposing a chicken-hearted wife, unable to bear the ignominy, were to cut her vein, or were to commit suicide, or were to smash her head against the wall, there your willful conduct has driven her to commit those acts. Then only it becomes a cruelty under 498A. Your mere act of slapping is only 323. I penned an article in the Kerala High Court cases, and he armed with that article, he got an acquittal. So that is 498A. Please bear in mind, whenever there is a matrimonial cruelty alleged, see that there is only a one-sided act on the part of the husband. That is not enough. That act should drive her to commit something, either suicide or cutting her vein or hitting her head against the wall or causing some harm to her. She should do that. Then only the cruelty as defined under the explanation will be satisfied, will be attracted. Anyway, for the question, you can, there are decisions, that is 221 Cr.P.C. enables a court to convict a person in cases where there is a doubt at the time of framing charge as to which of the several offences has been committed. So court can either frame charge in the alternative or can frame charge for all the offences. Therefore, in a given case, if the court has framed charge for only one offence, if the other offence for which court could have framed a charge is also revealed by the evidence, nothing wrong in the court convicting the accused for that offence also. Prema S. Rao versus Yadiya Srinivas Rao, AR 2003 Supreme Court, 11, AR 2003, Supreme Court 11, page 3. I'm sorry, 3 judges. Then Hiralal versus State Government of NCT of Delhi, AR 2003, Supreme Court 2865, Justice Arijit Pasai. Then Narvinder Singh versus State of Punjab, 2011, Volume 2, SEC 47. The judge is Surinder Singh Nijjar, Surinder Singh Nijjar, the author of the judgment. These are all judgments which explain the Nijjar. Oh, I'm sorry. After all, proper noun, even if it is mispronounced, you will excuse me. So all these decisions will throw light on the scope of Section 221, Clause 1 and Clause 2. We pass on to question number 4.
Sir, where the accused are charged under Section 302 read with Section 149 IPC, can they be convicted for Section 302 with the aid of Section 109 IPC without a specific charge under Section 109 of IPC?
Because when you charge a person for 302, reduce Section 149, you admit that you are stating that he was a member of an unlawful assembly, sharing the same common object of that assembly, and in that capacity he committed these offences. Even if he has not physically committed the offence, if a member of the unlawful assembly has committed the offence, he will be guilty for that. Even a non-performing offender will be guilty if he shared the same common object. That is the principle of vicarious liability under Section 149. Now, abatement is something, it is a distinct offence, as in the case of Section 149. Without a charge for abatement, you cannot invoke Section 149 by relying on Section 221. 221 is not an enabling provision for the court to convict a person with the aid of Section 109 abatement. There should be a specific charge because abatement it is a distinct offence, as in the case of 149, criminal conspiracy, 120B, etc. See Vakil Yadav versus State of Bihar, 2000, Volume 10, SEC 500, 2000, Volume 10, SEC 500, Justice Punji and Kurdukar. Then Joseph Kurian versus State of Kerala, AR 1995 Supreme Court 4, AR 1995 Supreme Court 4, by Justice M.M. Punji. There also, if at the time of framing charge there was no scope for any doubt as to whether there was abatement to commit the murder and punishable under Section 109 IPC, there cannot be any conviction under Section 109 IPC, even if the evidence discloses abatement. Even if the evidence discloses abatement, without an independent charge under Section 109 IPC, accused cannot be convicted. It is not a provision falling under the scope of Section 221, Clause 1 or Clause 2. But you must have seen that while discussing William Slani's case, Nanak Chand versus State of Punjab, AR 1955 Supreme Court 274, 3 judges, judgment authored by Justice S.J. Imam. The charge was under Section 302, reduced Section 34 IPC, and the trial court relying on Karnail Singh versus State of Punjab, AR 1954 Supreme Court 204, again 3 judges, C.L. Venkatramayya, which held that a conviction under Section 302 reduced 149 could be converted into one under 302 reduced Section 34, held that there could be no valid objection in converting a conviction under Section 302 reduced Section 34 into one under Section 302 alone, because 34, as we have seen while discussing William Slani, 34 is not a distinct offence. You are invoking Section 34 for the purpose of invoking the vicarious liability. And once 34 is invoked and the charge is with the aid of Section 34, participation in the offence is admitted. That is how the argument of William Slani was met by Justice Vivian Bose, speaking for the majority in William Slani's case. Participation is admitted. Then he cannot say that I have suffered prejudice because there was no charge, unlike 149. But if the charge is under Section 149, you cannot convict him for 302 alone in the absence of an independent charge under section 302. Because when you charge a person under 302 read with section 149, you are telling him that, look, Mr. Accused, you were a member of an unlawful assembly and you shared the common object of that assembly. Common object of that assembly included an offence to commit murder. Therefore, if any member of the unlawful assembly committed murder, it is in the eye of law, it is as if you also committed murder. Therefore, you can be convicted for murder. But once 149 becomes inapplicable, either because the number of persons becomes reduced to 4 or 3, less than 5, or some other reason, then you cannot convict him under section 302 alone without an independent charge. That is because that's the beauty of section 149. But that situation is not available when a person is charged under section 302 read with section 34, because in section 34, once it is invoked, once it is charge is framed with the aid of section 34, participation in the offence and in further common intention, these are all assumed. Therefore, you cannot say that I did not participate. I was only an onlooker. No, there should be participation for the purpose of 34. Whereas under section 149, even if you are an onlooker, if you share the common object of the assembly, you can be convicted for any offence committed by any member of the assembly. That's the distinction. Now, I will give you a small court charge by way of illustration, so that those of you who are judges, they may find it very, very important how to frame charge. I am going to give you an illustration. On 1/1/2021, at or about 6 p.m., the charge is framed. Again, the accused charge, there are five or more persons in a given case. Against every accused person, the charge is framed in this fashion. I am reading the court charge. On 1/12/2021, at or about 6 p.m., you were a member of an unlawful assembly, the common object of which was to commit rioting armed with deadly weapons, criminal trespass, wrongful confinement, and murder. And in prosecution of the said common object of that assembly, the first accused among you, inter alia, inflicted a deep penetrating stab injury on the front left chest of Rajiv, the victim, and you have thereby committed offences punishable under sections 143, 147, 148, 447, 342 and 302, read with section 149 IPC. This is the charge framed against all the 5 persons. In the charge framed against all the 5 persons, there is one extra statement. What is that? That extra allegation is that you are all members of the unlawful assembly for the purpose of committing criminal trespass, murder, etc., deadly rioting armed with deadly weapon, murder, etc. And in the course of at the same time, first accused among you inflicted a deep penetrating injury on the victim, as a result of which victim died. So you have committed all these offences. Supposing in such a case, the court ultimately finds that the 149 IPC is not attractive, either for the want of sufficient number of accused persons, 5 less than 5, or for some other purpose, 149 IPC becomes inapplicable, then the first accused will not be heard to say that in the absence of an independent charge against me under section 302 simpliciter, you cannot convict me for murder. Because in the charge itself, there is a statement that out of these members of the unlawful assembly, you, the first accused, inflicted the fatal injury on the deceased. Therefore, the act of framing charge is really an intelligent art. If you are intelligent, if the trial judge is intelligent enough to incorporate such a plea also in the charge, then even if the 149 falls to the ground, section 149 falls to the ground, the accused may not be able to escape. That's one. You may kindly bear that in mind. With that, we pass on to section 223, which is the last of the 4 exceptions to the rule of separate trial under section 218 clause 1. Please read section 223.
223. What persons may be charged jointly? The following persons may be charged and tried together, namely, persons accused of the same offence committed in the course of same transaction. Number 2, B. Persons accused of an offence and persons accused of abetment of or abetment to commit such offence. Persons accused of more than one offence of the same kind within the meaning of section 219, committed by them jointly within the period of 12 months. Persons accused of different offences committed in the course of the same transaction. Persons accused of an offence which includes theft, extortion, cheating, or criminal misappropriation, and persons accused of receiving or retaining or assisting in the disposal or concealment of property, possession of which is alleged to have been transferred by any such offence committed by the first persons, or of abetment or attempting to commit any such last named offence. Persons accused of offences under section 411 and 414 of Indian Penal Code, or either of those sections in the stolen property, the possession of which has been transferred by one offence. Persons accused of any offence under chapter 12 of Indian Penal Code relating to counterfeit coins, and persons accused of any other offence under the said charge relating to the same coin, or of abetment or attempting to commit any such offence, and the provisions contained in the former part of this chapter shall, so far as may be applied, all such charges, provided that where number of persons are charged with separate offences and such persons do not fall within any of the categories specified in this section, the magistrate or the court of sessions may, if such persons by an application in writing so desire, and if he or it is satisfied that such persons would not be prejudicially affected thereby, and it is expedient to do, try all such offences together.
Yes. Now, we will understand the section when we apply the same to the concrete fact situations. We will discuss question number 1. Please read question number 1.
Mr. Rao is reading.
Yeah. What is the scope of section 223 Cr.P.C?
We have seen section 223. It has got 6 clauses, A, B, C, D, E, F. Now, while section 218, 219, 220, 221 and 222 Cr.P.C deal with offences, section 223 deal with offenders. It refers to persons. All other sections which we have already discussed deal with offences. More than one offence can be tried together. Even if there are more offences, they have to be separately tried. All these rules we have applied in respect of offences. Now we come to section 223, which deals with offenders. Now A is persons accused of the same offence committed in the course of the same transaction can be charged and tried together under section 223 clause A. Now this clause corresponds to section 220 clause 1 Cr.P.C in the case of offences. 220 clause 1 we said more than one offence can be tried in the course of the same transaction. Here more than one person, more than one offender can be tried. So almost they correspond, they are mutually complementary. Now clause B, persons accused of an offence and persons who either abetted the offence or attempted to commit the offence can also be charged and tried together under section 223 clause B. So persons who committed accused of an offence and who have either abetted the offence or who attempted to commit the offence, all those persons can be offenders, can be charged together and tried together. With regard to the attempt, this clause corresponds to section 222 clause 3 in the case of offences, which we are going to discuss in the next session, 222. So with regard to offences, we have got the corresponding provision under section 222 clause 3. Now C, clause C is persons accused of 2 or more offences of the same kind committed by them jointly within 12 months can be charged and tried together under section 223C. This clause corresponds to section 219(1) regarding offences. Under section 219(1), we said that offences of the same kind can be tried together. Now here we see that offenders committing offences of the same kind can be tried together. Same, what is offence of same kind? They need not be the same offence. They can be offences for which same punishment is prescribed. Then clause D, persons accused of different offences committed in the course of the same transaction can be charged and tried together under section 223 clause D. This clause also corresponds to section 220 clauses 1 and 3 regarding offences. Regarding offences, we have seen 220 clause 1 and 220 clause 3. Those clauses correspond to this 223 clause D regarding offenders. Now E, persons accused of offences including theft, extortion, cheating or criminal misappropriation and accused of receiving, retaining or assisting in the disposal of concealment of property, the possession of which is alleged to have been transferred by any such offence committed by the first named person or abetment of or attempting to commit the said offence of receiving, retaining, assisting in the disposal of or concealment of this said property can be charged and tried together. Under section 223E, this clause partly corresponds to the proviso to section 219(2) in the case of offences, where more than the attempt, abetment, etc. also can the offence of attempt, abetment, etc. also can be tried along with the main offences. Here, the offender, main offender as well as the abetter, the person who attempted, they also can be tried in the same trial. F, persons accused of offences under section 411, that is dishonestly receiving stolen property. Then 414 IPC, assisting in the concealment of stolen property, or either of those sections in respect of stolen property, the possession of which has been transferred by one offence, can be charged and tried together under section 223 clause F. So this clause deals with stolen property. He may be either the thief himself, or he may be the receiver of stolen property, or the person who assisted in concealing the stolen property. All those persons are covered. Then G, persons accused of any offence under chapter 12 of IPC, that is offences relating to coin and government stamps, relating to counterfeit of coins, abetment or attempt to commit any such offences, can be tried together under section 223 clause G, provided that supposing there are numerous accused persons and all these offences are form part of the same transaction. As in the case of section 218(1), the accused persons also can make a request in writing that they can be jointly tried. And in that case, as in the case of the proviso to section 218(1), the court can jointly try them, even though joint trial is specifically not contemplated by section 223 Cr.P.C. when there are more offences and more accused persons, because it may cause confusion. It can cause misjoinder of parties, misjoinder of charges, because 218(1), if it is violated, we saw that it is amount to misjoinder of charges. But then even in such complicated situations, if the accused make a request in writing, court can try them jointly, so that thereafter they cannot turn around and say that, no, we have suffered misjoinder of charges, you have suffered prejudice. No, you will not be heard to say, because you had put in a written application. Then we pass on to question number 2.
Sir, is it not permissible for the accused to demand as of right his trial with co-accused under section 223 CRPC?
No. An accused person cannot claim to be tried along with the co-accused under section 223 CRPC. 223 CRPC is a provision enabling joint trial of more than one offender. Joint trial of more than one offender. But that doesn't mean that the accused can claim as of right to be tried along with a co-accused. In fact, this beautiful situation was decided in A.R. Antule versus R.S. Nayak. 7 judges, Constitution Bench. AIR 1988 Supreme Court 1531. 1531. The judges were Sabyasachi Mukherjee, the leading judgment, Ranganath Misra, G.L. Oza, B.C. Roy, S. Nadarajan, M.N. Venkatachalaya, and S. Ranganathan. Now, in this case, the majority held that the suo motu transfer of transfer by a constitutional bench of 5 judges in a 1984 2 ACC 183, that was on 10 to 1984, of the corruption case of Mr. Abdul Rahman Antule, the former Chief Minister of Maharashtra, from the file of the special judge, Greater Bombay, exercising jurisdiction under the P.C. Act 1947 and Criminal Law Amendment Act 1952 to the Bombay High Court. The case was transferred, suo motu transferred by the Constitutional Bench, 5 judges, from the special judge under the P.C. Act to the Bombay High Court with a direction to the Chief Justice to assign the case to a sitting judge of the High Court for trial. That suo motu transfer was held to be illegal by this 7 judges Constitutional Bench. Very rare situation. Supreme Court itself sitting in virtually in review against its own judgment, 5 judges judgment. But in fact, there was no application by either of the parties for transfer of the case from the special court to the Bombay High Court. In fact, that was suo motu done by the Constitutional Bench. 7 judges, majority held that no, it was not legal. When the statute has prescribed a particular forum for the trial of case, just because one of the accused is a big shot, just because one of the accused is a former chief minister, he cannot have the privilege of being tried by a judge of the High Court. Very strange situation. Yes, extraordinary situation. Question number 3.
So before we take the question, what could be the reason for transfer for the common persons to understand?
It is stated by the 5 judges bench. They said after all he was a former chief minister of Maharashtra, and the court is yet to find him guilty. So he is armed with insulated by the presumption of innocence. He is to be presumed to be innocent until found guilty. So he had occupied various positions in various posts. Therefore, such a person should receive a better forum. That's the reason given by the. In fact, he did not request. He did not request, and the prosecution also did not request for transfer of the case. Case was pending before the Greater Bombay Special Judge under the P.C. Act. The court suo motu on its own accord said that he is a person who had occupied great positions, including the chief ministership of Maharashtra. So such a person, the special judge who is only a district judge, because law is not a respecter of persons. This is what the English judge said to Mahatma Gandhi. Law is not a respecter of persons. Before the law, every person is equal. Therefore, the 7 judges Constitutional Bench held that this transfer was illegal and void. What happened was actually 57 accused persons, 57 witnesses had been examined by the judges of the Bombay High Court, 2 or 3 judges, one after the other. 57 witnesses were examined. It is at that stage that the 7 judges Constitutional Bench held the transfer to be illegal, and the case was sent back to the special judge for de novo trial. Question number 3.
Sir, Is not clubbing and consolidation of two cases, one on a police challan and other on a complaint, permissible if the prosecution versions in the two cases are materially different, contradictory, and mutually exclusive?
See, there is one case which is investigated by the police. There is another case where the accused has, where the complainant, de facto, the complainant has given a private complaint. Both cases are under investigation, are going on. Then the question is whether they can be consolidated and jointly tried. 223 is a provision for joint trial of more than one offender. Now the question is, when the facts constituting the offence in the two cases are materially different, as is stated in the problem, then there cannot be a joint trial or consolidation. They have to be tried separately, but by the same court. They have to be tried separately. They cannot be amalgamated. They cannot be jointly tried. They can be tried only one after the other in quick succession. And the evidence in one case cannot be read into the other case. And they have to be tried and disposed of simultaneously, one after the other. This is what the Supreme Court held in Harinder Singh versus State of Punjab, AR 1985 Supreme Court, page 404. Justice A.P. Sen speaking for the bench. AR 1985 Supreme Court, 404. Then question number 4.
Question number 4. Can persons accused of several offences and persons accused of abetment of those offences be tried together at one trial?
Yes, we have seen this section. We saw in the section itself that they can be the offenders of the main offence and abettors and persons who attempted to commit the offence. They can also all be tried in one single joint trial. You may refer to the majority view in paragraph 19, 20 and 23. Paragraphs 19, 20 and 23 of the majority view by S.J. Imam in case Satwan Singh versus State of Punjab. 5 judges decision, AR 1960 Supreme Court 266. AR 1960 Supreme Court 266. 5 judges. Yes, question number 5.
Are not the conviction and sentence recorded by the court in a joint trial amounting to misjoinder of charges invalid?
No. Conviction and separate sentence recorded by court in a joint trial will not amount to misjoinder of charges. In the absence of any objection to the joint trial and proof showing that failure of justice had occasion, the conviction and sentence in a joint trial cannot be invalid. This is what the Supreme Court held in AIR 1989 Supreme Court 937. AIR 1989 Supreme Court 937. Premchand versus State of Haryana. Judgment by Justice Reknavel Pandyan. Justice Reknavel Pandyan. Yes. With that, we have come to the close of section 223 CRPC. So we have discussed all the 4 exceptions to the rule of separate trial under section 218(1) CRPC. The exceptions are section 219, 220, 221 and 223. What remains to be discussed is section 222, which is really not an exception to the rule under section 218(1) CRPC.
This is by Mr. Reddy. Under what circumstances section 120 subclause B can be invoked in absence of the accused being present in the place of incident?
I didn't get the question.
He says under what circumstances section 120B can be invoked in the absence of the accused being present on the place of incident.
Criminal conspiracy, the conspirator need not be present. In fact, all conspiracies are done in extreme secrecy. So he need not be present. So if it is to be shown that he was among the persons who hatched the conspiracy or who indulged in the conspiracy, he can be roped in with the aid of section 120B and and we have already seen that even if the offences for which they hatched the conspiracy have not been proved, if conspiracy element has been proved, they can be convicted for conspiracy, which is an independent offence under section 120B IPC.
In a final order, can GMIC in application under section 156(3) for offence under section 466, 467, and 420, while dismissing the complaint, can mention that even forgery of original complaint does not affect the complainant in any way and now bring preliminary evidence?
I didn't get the question.
I think he means that the magistrate, while rejecting the application, said
Application means complaint. Private complaint.
Complaint under section 156(3).
153 is the forwarding to the police. 153, the complaint is forwarded to the police for investigation.
Yeah, for 156(3), like he's rejected the 156(3) application by saying that even though there is forgery in the original complaint, you are not affected by it. I mean, that should not be the consideration of the learned magistrate, but he's taken that into consideration. I don't know. It would be wrong on his part.
But if he's going to take cognizance of the offence, well and good. He may say that I am not going to forward it to the police. I am taking cognizance of the offence on the complaint. Then what could be the prejudice or what could be the heartburn for the complainant? That option is also there for the magistrate. Magistrate has got the option either to take cognizance or to forward the complaint to the police under 153, or he can ultimately reject the complaint, dismiss the complaint after taking cognizance. Dismissal of the complaint under section 203 CRPC can only be at the post cognizance stage, not before cognizance. Before cognizance, we discussed that it can only be rejected. My view got virtually affirmed by the Supreme Court in another case, 2015 Supreme Court. That was my view in 2009. 2008 or 9. I had taken the view that if the complaint on the face of it does not reveal the offence, then the magistrate need not undergo the ordeal of taking cognizance of the offence, examining the complainant on oath and the witnesses, then proceeding to 203, under which at that stage alone he can dismiss the complaint. But if the complaint on the face of it, ex specie, does not make out any offence, he does have the power to reject the complaint. You can't call it dismissal. Dismissal is under section 203 after cognizance. But even before cognizance, at the threshold, complaint does not make out any offence, does not allege the ingredients of the offence. He can reject the complaint, which view taken by me in 2008 or 9 got the approval of the Supreme Court in another case in 2015. Supreme Court also took the same view. There can be a rejection, though CRPC is silent about rejection.
So this is by Arun Pratap. If same offence is committed during 2 years, then separate charge for 1 year and separate charge for second year has to be framed or not?
Yes.
Okay. And then he says, is a joint, this is by Aditya Reddy, a joint trial of several persons permissible?
Joint trial of?
Several persons permissible.
Yes, 223, that is the provision, enabling provision for trial of more than one offender. Plurality of offenders, 223. Plurality of offences, 218 to 221.
And then it says by Kumar Madhukar, Lordship does an order under section 91 in a magistrate court is intermediate order or an interlocutory order?
19
Section 91. He says it's an intermediary order or an interlocutory order.
You mean for issuing summons for production of document?
Production of documents.
Production of documents, it can only be an interlocutory order because it does not affect the progress of the case. Is it not? Does not affect the progress of the case. If it does not affect the progress of the case, it can only be an interlocutory order which is not revisable. But of course, 482 can be invoked before the High Court. Power under 482 is always there. Even if the order is not revisable due to the fact that it is an interlocutory order, the power of the High Court under section 482 is always there. High Court can examine that. Because 482 itself starts by saying that nothing in this code will curtail the power of the High Court, inherent power of the High Court. 482. So the code, the other provisions in the code will not act as a fetter on the power of the inherent power of the court under section 482 CRPC. Even if the order is not revisable due to the fact that it is an interlocutory order, 482 power can be invoked.
Edison Ganraj, though I believe that he had to reframe the question properly, but still I will read what he has posted. A is accused of a theft on one occasion and of causing grievous hurt on another occasion. Two offences were included in one charge and were tried together in a single trial by the magistrate. A was convicted. Is that the validity? Is the conviction valid?
If he did not raise any objection, he should have taken exception to the joint trial because they are not part of the same transaction. They are part of two different transactions and distinct offence. 218(1) rule of separate trial under section 218(1) should prevail. And joint trial is permissible there only if he makes a written request. Therefore, it may be possible for him to say that the trial of both the offences is illegal.
Aditya Reddy has posted many questions, but I will read one question because some are more of an informative rather than questions. Without and before deciding the crucial question, no consolidation of charge should have been directed under section 220. He's trying to answer what the question was there.
He's right.
We are happy that people are participating. The more the activity in the YouTube, we come to know what type of sessions people want.
Yes.
And we would rather appreciate if somebody posts on the link that what type of sessions and questions they would like to ask.
Yeah, don't treat me as an expert. I am only trying to answer within my limited knowledge of criminal law, which is an ocean.
But your knowledge is as vast as 482 or 226. Thank you, sir. We will take the next session forward next time on 220.
220. What remains is 220.
Yeah. Thank you, everyone. Stay safe. Stay blessed. And on 10th, we will be having some slightly different. Dear friend of mine, we are launching a book. There is a different book, different aspects of military law being discussed of the PAN, March of Military Law, PAN World. So do stay connected with us on Friday, 5:30 p.m. Everyone stay safe, stay blessed. It is by Navdeep Singh. Thank you.
Thank you.